And the future of how Guam chooses its next political status continues to be weighed by the local and federal court, but a recent ruling in a similar case in the Commonwealth of the Northern Marianas could hint at how the U.S. government's judicial branch feels about the matter. Last week, the Ninth Circuit Court of Appeals ruled in favor of John Davis, the man in 2012 who sued the CNMI government over not being allowed to vote on changes to land ownership provisions in its covenant. As it stands, eligibility is tied to ancestry, similar to how Guam's laws identify who can vote on Guam's quest for self-determination. Davis and his lawyers argue the criteria is unconstitutional, while the CNMI claims its race-neutral policy is not unlawfully discriminatory. Now, both the lower and appellate courts have sided with the plaintiff in that case. The most recent ruling proclaims, quote, the 15th Amendment aims to prevent precisely this sort of division in voting, end quote. Coincidentally, Guam is facing much of the same. Our local law makes ancestry a criteria for registering for a decolonization plebiscite. When Arnold Dave Davis tried to be included, he was denied because his ancestry made him ineligible. And so he sued, arguing, like the CNMI's Mr. Davis, that the policy is unconstitutional. Guam's case is back before Chief Judge Frances Tydenko Gatewood. She initially dismissed the suit, ruling the issue was not ripe for remedy, but was overruled by the Ninth Circuit. In that decision, justices cautioned, quote, Guam must hew to federal constitutional criteria when determining who is eligible to register, end quote. Davis, represented by the Washington, D.C.-based Center for Individual Rights, maintains that because the 14th and 15th Amendments of the Constitution prevent any race from being denied a right to vote and afford equal protection to American citizens, Guam's statute over self-determination eligibility are unlawful. Meanwhile, the government of Guam, represented by Special Assistant Attorney General Julian Uggan, argues that ancestry-based classifications are legal in unincorporated territories, that a plebiscite is not a constitutionally protected election, and that any disparity arising from our self-determination process must be shown, quote, in some meaningful way with lived, not imagined, reality, end quote. And just today, Dave Davis's attorney, Christian Adams, submitted a letter to Guam Chief Judge Gatewood to notify her of the CNMI decision.